If I could ask members and witnesses to take their seats, please. Good afternoon and welcome to the 23rd meeting of the Standing Committee on Aboriginal Affairs and Northern Development. Today we are continuing with our hearings on Bill C-30, an act to establish the Specific Claims Tribunal and to make consequential amendments to other acts. A couple of quick housekeeping notes. As I've said a couple of times recently, we have a few meetings this month with only a couple of witnesses and a couple of meetings with many, many witnesses. And today we're going to have many witnesses and many presentations, so we're going to need to move along briskly in order to be done. We have two panels. There will be 3 presentations from each panel. The presentations will be limited to 10 minutes, severely limited to 10 minutes. In fact, I'll give you a 1-minute warning. So at some point I'll chime in and just say 1 minute. You don't need to stop, but that's just to let you know. And that is because we have 1 hour and we need to get through 3 of these presentations. We'll only have time for 1 round of questioning, and I'm thinking that 5 minutes for each questioner will be all we can do. That's because we have bells at 5:30 today for votes, and we have many votes tonight. So I'm going to try to get through both of these panels in 1 hour each. So with that, I'd like to welcome our guests here today. And we have representatives Christopher Devlin from the Canadian Bar Association, Kathleen Lickers from the Indigenous Bar Association, and Alan Pratt from Alan Pratt Law Firm. So as I said, if you could give us a presentation of 10 minutes or less. Following, we will do a round of questions, and the individual members will be able to direct their questions to whichever of you they wish. So I'd like to begin with Mr. Devlin. Welcome, and you have 10 minutes.
Well, thank you very much, and good afternoon, members of the committee. I'm here on behalf of the Canadian Bar Association National Aboriginal Law Section, and we're pleased to be here to present our views on Bill C-30. The CBA is a national association of over 37,000 law students, lawyers, and notaries and legal academics. And one of the aspects of the CBA's mandate is improvement in the law and the administration of justice. And it's under that objective that we're appearing before you today. Now, I understand that the committee has received has had several hearings already on this bill, and I don't intend to do any background information on Bill C-30. I've read some of the evidence summaries, and it's been quite extensive. The CBA is making 9 recommendations to this committee, and I intend just to touch on them very briefly in these opening comments. First of all, the CBA, National Aboriginal Law Section, supports Bill C-30 generally. It's a long overdue law reform to the existing specific claims process. However, in the interests of law reform, we think that there are a few areas that need to be improved, and we'd like to present those recommendations to the committee today. Our first recommendation deals with the power of the Specific Claims Tribunal to issue final and conclusive decisions for compensation respecting claims. I'm referring to sections 14, 17, 20, and 34. Section 34 sub 2 is a very strong privative clause. So section 34.1 allows decisions of the tribunal to be subject to judicial review, but then subsection 2 is the strong privative clause. Other witnesses before you have raised a concern with the inability to appeal decisions of a tribunal panel. And what the CBA is recommending is that, like other specialized administrative tribunals, there be some kind of internal review process. So the judicial review function is important, but as we certainly, as some of us know, judicial review is subject to a much higher threshold in order to overturn the decision being reviewed. And what we're recommending is that, not unlike the Immigration and Refugee Board or like provincial worker compensation boards, there be some second level of review internal to the tribunal, so that if there are errors of a particular judge, they can be caught internally. And then, of course, there's a judicial review. The second recommendation that we have really goes to the limits of jurisdiction, and we have 3 recommendations under that heading. We have 3 concerns with the proposed limits on the jurisdiction of the tribunal. The first is that the tribunal is only limited to awarding financial or monetary compensation. And you've heard extensive evidence on this already. I'm not going to belabor the point. The specific concern we have with respect to not allowing the tribunal to consider issues of land and make determinations on land is that there are certainly at least one whole category of specific claims, treaty land entitlements, which are all about land. And certainly at the negotiating table, when Canada is negotiating with First Nations on treaty land entitlement claims, as an example, land and cash is always on the table. You've heard some witnesses, particularly out of Saskatchewan, say that they rarely is land on the table, it's always cash. But in other provinces, certainly the ones that I'm familiar with in Alberta and British Columbia, there's always a land portion and a compensation portion. So in order to, and the tribunal is supposed to be making final determinations of these specific claims. And so the CBA believes that the tribunal should have jurisdiction to, in the very least, make declarations respecting the land quantum that Canada should provide, or that's the lawful obligation that Canada has to the First Nation, and also the nature of those lands, what kind of lands the First Nation would be entitled to. That certainly would play into the determination of any compensation that Canada would provide to the First Nation, and it's definitely something that should be within the tribunal's jurisdiction. We note that although Canada has not adopted the UN Declaration on Indigenous Rights, that compensation can take the form of land and is properly within the spectrum of Indigenous rights, and we feel that that also should be within the tribunal's purview. Our second concern with the limits of jurisdiction is with respect to the harvesting rights, or the land use rights, and that's under section 15 sub 1 sub G. This provision appears to be directed at treaty rights such as hunting, fishing, and trapping. There is, while the CBA is not suggesting that present use of land rights should be subject to the Specific Claims Tribunal, there are historical grievances that should properly be specific claims that the tribunal can hear. And the example of that is the imposition of provincial trap line registration systems back in the 1920s and 30s, which essentially obliterated traditional trap lines of First Nations. And of course, the traditional trap lines of the First Nations were protected under the treaty rights under their respective treaties. So those sort of historic grievances of these rights should fall under the jurisdiction of the tribunal, and we have that as our second recommendation under this section. The third one is a very specific one, and it refers to section 14 sub 1C, and that refers to with respect to Canada's obligations with reserve lands, to unilateral undertakings that give rise to a fiduciary obligation at law. And the CBA Aboriginal Law section notes that often there's a dispute between First Nations in Canada as to what constitutes a fiduciary obligation, and that sometimes there may well be a legal obligation there, but it's up for a difference of opinion as to whether it meets that higher threshold of being a fiduciary obligation. In that respect, we would recommend that the word fiduciary be deleted from that subsection, so that what we're talking about are obligations in law. The limits to the tribunal's monetary jurisdiction, the committee has heard extensive evidence on that. The CBA would like to add to that the concern about the arbitrariness of that monetary limit. However, the specific concern is this. with respect to relatively straightforward claims that only but for the passage of time would pass that $150 million threshold, they should be subject to the tribunal's jurisdiction. Now, what I mean by that is reference to the recent Whitefish Lake First Nation decision of the Ontario Court of Appeal. When we're talking the application of arithmetic of equitable compensation that allows compensation to the First Nation to bring the loss of use forward from the late 1800s into the early 21st century, if it's otherwise a straightforward claim, it's not complex, it's not a bundled claim, then the tribunal really should have jurisdiction over that. It's not a huge issue of law. It's only by virtue of the application of arithmetic that where you'd see the actual compensation exceed the $150 million mark. So we say that the tribunal there should be a provisional cap of $150 million, but that the tribunal can assess the complexity of the claim and whether or not it has the jurisdiction. If there is just a simple arithmetic calculation that exceeds it, the tribunal should have jurisdiction.
1 minute.
In Section 35, under the release provision, the CBA recommends that it's unfair to require a release for all the rights that may flow by the First Nation from a particular set of facts. If Canada wants a release on a particular cause of action, a particular claim, then that's all it should get. It shouldn't get an open-ended release so that on the same facts there could have been an Indian agent that took certain actions that resulted in several specific claims. But if only one of those claims is before the tribunal, then Canada should only get a release on that one claim. The last two recommendations, I will go to the last recommendation because I want to highlight this, and this is on the minimum requirements to be included in a claim. There has been the minister referred to this in his submissions before the committee. We say that the minimum standard of what constitutes a reasonable application should be set out in the legislation, at least the bare bones, and we give some suggested minimum standards there in our final recommendation. Thank you.
Thank you, Mr. Devlin. That was great. Ms. Lickers, you have 10 minutes.
Well, good afternoon. I appear before you today on behalf of the Indigenous Bar Association, and you do have a copy of our brief, and I don't intend to read that brief, but rather it's my intention to speak more directly from my heart, I suppose, and to encapsulate certain of our views towards the need to reform the process. I am a Seneca from Six Nations. I am intimately familiar with Canada's land claims process. I have been Commission Counsel for a number of years to the previous Indian Claims Commission, and I was also counsel to the Ipperwash Inquiry. And so I know firsthand what it looks like for the specific claims process to fail on the ground. In my view, every legislative attempt of this country since the 1960s that has sought to address the matter of specific claims has sought a recognition that these matters do call for justice to be done. But our failure as a country to come to grips with these issues is what leads us here today. And asking the question, is it this bill? Is it Bill C-30 that gets us there? Is it what's needed? It was Canada's failure, I believe, as a country to balance what was needed in 1974 when it was asked and striking the Office of Native Claims. And it was foreshadowed then by the Supreme Court of Canada Justice Laforêt, even then when he said that the fundamental objectives of finality and independence screamed out to this country on these issues. In fact, if you go back to the Hansard debates of the original recommendation for an independent claims tribunal, of the First Nation witnesses to the first parliamentary committee, the predecessor to this committee, who joined jointly with the Senate, who incidentally my grandfather, Norman Lickers, was the Commission Counsel too. If you read the Hansard debates from that time period, you will see in that record the representations of First Nations across this country who explained in words far more articulate than I as to why there is outstanding treaty business and what needed to be done. So until now, Canada as a country has asked First Nations to find justice in a process that it has single-handedly designed. And it not only did it design it, but it delivered it from within the walls of the very department whose actions were to be impugned. And then you ask the question why the rest of the country in Canada poses to us, why can't this be solved? Why do these issues remain? But to the First Nations you ask, should we change this? And the answer is a resounding yes. The question that I believe you have as a committee, after hearing from as many of First Nation Canadian witnesses with experience that have brought to you very technical representations, heartfelt representations, I believe that the question that is left with you after hearing all of us is that is C30 and all of the amendments that are being proposed, does it get us far enough? And are the amendments that are being asked of you such that they can be addressed within the mechanisms that the bill sets out? Within the mechanisms of the bill, you have a 5-year legislative review. Within the mechanisms of the bill, you have the capacity to strike advisory committees. You have the capacity to address the call for elders' councils. You have the capacity to, by its structuring of its rules, design with the expertise of lay people and legally trained people throughout the country for it to design its process. You also have an oversight committee within the terms of this bill. And I say to you, as I will as I conclude further on in my remarks, that I do believe there is a role for this committee. But let me get to my very substantive remarks on this bill. It is the position of the Indigenous Bar Association to support this bill. We come here making no recommendations for amendment. We do take caution in a few areas. But let me start with why we support this bill. First of all, it is a matter of establishing the independence of the process from outside of the walls of the Department of Indian Affairs, and frankly, from the outside of the Department of Justice, whose advice is called upon repeatedly. We also take the opportunity to note that with the striking of a tribunal, it represents for Canada another opportunity to ensure that the justices that make up that tribunal include Aboriginal justices, and that you take the opportunity to appoint further Aboriginal justices to the superior courts of this country, and by doing so, draw a larger pool of people to the process by which it is being designed. There are, for First Nations in this bill, a more leveling of playing field, and they come clearly and squarely in the form of timelines. Without this bill, the status quo remains, and the status quo would have every First Nation claimant band waiting and waiting and waiting. Bill C-30 creates a remedial step to level the playing field and puts into the hands of First Nations a remedy to hold the Government of Canada to account for its failure to respond in a timely manner. That might seem trite to anyone unfamiliar with the claims process. To anyone familiar with the claims process, that is an enormous change. The subject of oral history is one that I personally hold dear. Having been Commission Counsel to the Indian Claims Commission for a number of years, and it being the only post-OCA institutional improvement to the claims process in this country, for one thing. But secondly, it was the first institution in this country that sought, as a matter of its process, to include oral history in the evidentiary formation of the claim. There is a body of work by which this tribunal can draw from. There is a body of work for protocol. It is also a role for this tribunal to strike an Elders' Council. That's within the purview of the bill. That does not require amendment. On the subject of land-based specific claims and why it is that the IBA takes a position not to make a recommendation for amendment on this point, we accept the fact, with some notable objection, that $150 million is a financial cap. That has to do with cabinet mandate. That does not have to do with the subject matter of that section of the bill. On the point of the land, its inability to award land compensation, there is a fundamental need for a tribunal outside of the Department of Justice to actually render findings on land-based specific claims that are called treaty land entitlement. And the reason is this: having the experience and body of work from the Indian Claims Commission, there is a role for justices to make determinations of land quantity and land quality. What does it mean for a First Nation to say that all of the lands by which they were entitled under treaty were not provided to them? Either because not enough Indians showed up on the day that the Treaty Commissioner took the pay list analysis.
1 minute.
Or that the land by which they were originally assigned was swamp. I speak in very stark terms, but those are the realities of the claims that come before the process. There is in my final minute, I suggest to you a role for this committee, a further role for this committee that goes beyond what is the clause-by-clause review. And it is this, that there is too much responsibility to be placed on C30 if we in the country believe that it is the only answer, that everything about the specific claims process will be improved by C30. The answer to that is actually shaped by the political agreement. All of the elements that go to ensure a more fair process don't all exist within this bill. And I put it to you that there is a role for this committee to ensure that what is outside of the bill but finds itself in that political agreement is overseen by you. Thank you.
Thank you very much, Ms. Licurse. Mr. Pratt, you have 10 minutes, sir.
Thank you, Mr. Chairman. I'd like to do what is probably a very bad idea, and that is to begin by apologizing to the committee. I had every intention of getting a submission into the hands of the committee before today, and unfortunately you don't have one. The committee does have a submission, but it hasn't yet been translated, so I will be making reference to a document that you'll have to perhaps wait a few days for. Oh, you have it. Oh, sorry. Okay, you have it. Okay. So that's the last one.
The members do have this submission.
Okay.
Please take for granted that we have read it, sir.
Thank you. That's great. Well, I'm going to, in the limited time, indicate that I am here as, unlike my colleagues, as a private citizen, but I am a legal practitioner. I've worked in the field of specific claims since about 1985. Ms. Licurse mentioned the Indian Claims Commission. I was actually counsel with Mr. Winogren, who's in the room here, on opposite sides of the very first claim that went to the Indian Claims Commission in the early 1990s. The bill, for me, is one. My reaction is mixed. It is clearly an advance over what we've had before. It's an advance over the Specific Claims Resolution Act, but I believe that it is lacking in a number of quite important ways. So I have made 8 recommendations, and since you have seen my submission, you've seen that I've not only made recommendations, but undertaken the task of drafting clauses that might remedy the deficiencies in the bill that I've identified. I do want to say that, and as I mentioned in my submission, in 1963, Parliament considered a bill to introduce a Specific Claims Commission, and that bill failed. It's an interesting historical footnote, perhaps, but part of the exercise was an evaluation at the time of the overall amount of money it would take to settle all claims. And the total estimated in 1963 to settle all specific claims was about $6 million. $6 million. I think that that's off by a factor of 1,000, and if you correct it for inflation, it's still a lot. It's still a major underestimation. I start by saying that because if this bill is not the answer, or does not lead to something which will be the answer, this amount of money that is owing as a debt to the Canadian state will simply continue to increase at an alarming rate. So it is very important to our long-term future that we fix the problem that you've heard about. My first recommendation relates to the reconciliation function of the tribunal. The bill, in its preamble, notes correctly that reconciliation is one of the outcomes of settling land claims. But the tribunal is not a reconciliation body; it's an adjudication body. So I have made a recommendation that there be a mandatory pre-hearing conference involving mediation, so that even after all the steps are taken, once you're in the tribunal, there must be a mandatory hearing in the nature of mediation before it goes to a formal hearing, and that the member of the tribunal or members conducting the mediation not be involved in the hearing. The second recommendation also relates to reconciliation. Like Mr. Devlin, like the CBA, represented here by Mr. Devlin, I believe that the tribunal should have the authority to make certain declaratory orders. And he mentioned the Declaration of Rights Respecting Land. I have recommended 3 other types of declaratory orders that I recommend that the tribunal be authorized to make. One is to recognize that a Crown breach has caused a non-pecuniary loss, which means a social or cultural loss to a First Nation. That's a very important recognition in the healing process of claims. Second, in some situations, the Crown should be told by the tribunal that it should apologize to a First Nation. And third, the tribunal should have the authority to make the declaration that if a First Nation chooses to accept something less than it is fully entitled to, that by accepting that, the First Nation is making a generous gesture in favor of the people of Canada. And some of those points have arisen out of the practice in New Zealand, and I think that the committee may benefit from hearing more about that. A third recommendation relates to a confusion in the bill, and this relates to Section 11 of the bill primarily. The bill makes it clear that when a claim that has been accepted is in negotiations for 3 years unsuccessfully, then the tribunal has jurisdiction. It doesn't make it clear that the claim continues to be regarded as valid. It opens up the question that the First Nation may have to reprove the validity of its claim. So I don't think that's the intention, but it is not clear that the tribunal's jurisdiction in that situation is only about compensation. My second point under this heading is that the First Nation should have the right, in my view, to seek to put the validity of a claim before the tribunal, and then, if it is successful, have an opportunity to negotiate it before the compensation ruling is made. So my amendments, suggested amendments, I think open up and make more flexible, partly, I think, make more clear what the intention is with regard to the first point, and on the second point, to give the First Nations more flexibility and foster negotiations. My next point relates to costs. The tribunal is basically asked to create a costs regime that's consistent with the federal court rules. That means it is likely that First Nations will be penalized in costs if they are not successful. I have recommended 2 changes. One, providing for advance costs to be awarded by the tribunal, so that First Nations going into a hearing will be able to afford to appear. That's consistent with the current practice. Secondly, that at the end of a hearing, the tribunal should have a discretion regarding costs, but unless there is some exceptional factor, like bad faith on the part of a First Nation should not be compelled to pay the costs of the Crown. My next one is the definition of claim, and I'll touch on some of the rest of these very quickly. There should be, I believe, in subparagraph 14(1)(d), reference to an illegal or improvident lease. The clause at the moment talks about an illegal lease or disposition. I believe that it leaves out an important possible source of claims, which is a disposition or lease which is legal in the sense that it has been validly granted, but is improvident in the sense that the consideration is inadequate. So the addition of those words would remedy that, and it's consistent with case law that I have referred to in my brief. Next, I think is something quite important: exclusion of certain relief. The tribunal is not permitted. I think this is a very, very grave problem with the bill, that the tribunal is not permitted to grant punitive damages or non-pecuniary damages, even if a court would make such an award in the circumstances of a case. I think it is entirely improper for the Crown to ask for a First Nation to set aside a type of relief that a court might well award. I'm not saying that it would award, but it should be an issue to be resolved through the evolution of case law and through the tribunal's decisions. And I've recommended an amendment which reaffirms, in fact, the jurisdiction of the tribunal to grant those types of relief. My next point, second to last point, relates to claims where there is reserve land involved. And you've heard already some concerns about the breadth of the release clause. In my opinion, if the subject matter involves releasing the rights to a reserve, the First Nation in question should have the opportunity to decide whether it is prepared to accept an award of the tribunal in exchange for an absolute surrender of its reserve land. It may or may not.
1 minute.
Thank you. May or may not agree that a surrender in exchange for the compensation awarded is proper. One of the difficulties with this bill is that it isn't clear how a First Nation is mandated by its members to initiate a proceeding in the tribunal. And it's quite possible that a majority of a chief and council, without any further mandate from their members, could initiate a proceeding that would lead into the extinguishment of rights to reserve land without ever consulting with or seeking the informed consent of the members. I have suggested amendments to deal with that. And my final point echoes one of Ms. Licker's points, and that is, in the bill, the Minister of Indian Affairs and Northern Development is listed as the responsible minister for purposes of the Financial Administration Act. This reaffirms the connection between that minister, his department, and the administration of the specific claims system, and in my submission, that should be terminated. Thank you.
Thank you, Mr. Pratt. And our three witnesses have set an excellent example for committee members in terms of staying on the clock. I ask my colleagues we have 5 minutes each. I would ask you to not have a very long preamble followed by 4 questions, leaving only 30 seconds for answers. So again, we will begin with the first round, 5 minutes. Ms. Keeper from the Liberal Party.
Oh, no, Mr. Russell's.
Oh, pardon me, Mr. Russell.
Thank you, Mr. Chair, and thank each of you for your presentations. Ms. Licker, certainly I heard your impassioned plea to pass this piece of legislation without amendment, and that the committee certainly sort of had probably more to do with how this is wrapped. This piece of legislation is wrapped by the political accord and other factors. I would only just argue that I think we have more to say about this particular piece of legislation and can make more changes about this particular piece of legislation which is on our table now than some of the other political nuances that may surround it. But that's a debatable point. I want to raise 2 issues. The issue of land and the fact that the tribunal cannot award land or really make any declarations regarding the awarding of land arising from its decisions. Now, Mr. Devlin, you have suggested that we want to make declarations, that we should expand it at the least to make declarations respecting land quantum and the nature of such lands owned by Canada to a First Nation. What does that do in a practical sense? You know, if say we included that amendment, now each of you can comment on that. What does it do in a practical sense? Does it force maybe a more open negotiations or people to negotiate a settlement? You know, what does it do in a practical sense? And then the second question is around the release, because these issues have been raised before by myself and colleagues. And I remember the Indian residential schools debate, when the Crown was going to make certain awards to individuals or survivors of Indian residential schools. They would not compensate them for loss of language and culture. This was a huge issue. But they wanted them to release all claims against the government for any loss of language and culture. This was a hugely emotional issue affecting individuals and communities, and one of the real stumbling blocks, I think, to any type of process until we had this Indian residential schools agreement. And I see this being resurrected somewhat here in the release provisions. So I just want you to comment on those two aspects: the land declarations and what it does practically, and on the release provisions again.
I'll be as quick as I can. On the land issue, I think it raises two sub-issues. One, which is following up to what my colleagues have spoken about, which is the need of the tribunal to have flexible rules. Under the legislation right now, there's an opportunity for case management before the hearing, and I think that whatever rules the tribunal adopts should also have the opportunity to bring preliminary motions. The reason I'm suggesting that's a partial answer to your question is that if there's a stumbling block at the negotiating table where the Crown and the First Nation just can't see, there's a huge gulf between their two positions, if the tribunal is able to either make a binding decision on that issue as a preliminary motion but not as the final determination, it may actually facilitate the successful negotiation of the claim. So we don't have the rules of the tribunal in front of us. We have some guidelines in the legislation what can be there, but and I haven't seen Mr. Pratt's suggested amendments, but certainly under the kinds of rules that the tribunal can adopt for its own procedures, one of them should, and maybe this will fall under the case management, or maybe it will be an independent ability to hear preliminary motions on specific issues. So on the land quantum issue, for example, and this leads to the second sub-issue, very often a province is involved. Not all the time. Sometimes the federal government has some very nice pieces of land that First Nations would like to have as part of their settlement, and that can be made available. And the recent Musqueam case comes to mind in Vancouver, with a block of downtown Vancouver being set aside for their treaty negotiations. But that aside, the province often has the good real estate. Well, if there's a declaration as to how much land is required, is owed by Canada, that actually may facilitate the trilateral negotiations with the province. The province says, oh, that's how much we have to cough up? Well, now we can quantify that. Now we know for certain. On the release issue, the loss of culture and language, I was also in front of the committee on those on that hearing as well, and as my recollection is, Canada backed off on the release on that and stopped requiring a release of on loss of culture and language, and said, okay, we're only going to require a release on the physical and sexual assault. So I think that Canada should do the same thing in this bill and say, you know, not an eye for an eye, but you know, this is what you're getting compensated for, so this is what we're asking the release for, as opposed to being too broad.
Thank you very much. Monsieur Lemay from the Bloc, you have 5 minutes.
Oui. Alors.
It's unfortunate because I would have so many questions for you, and I know that our colleagues, lawyers, love talking, sometimes too much. And I've told you to take for granted that we have read your briefs. Now, I have so many questions. I won't have time for all of them, but I think we have to avoid coming back before Parliament to amend legislation which has already been passed. I would ask you to interpret Section 12. Now, upon reading Section 12 of this bill, doesn't this section meet most of your requests if there were rules of procedure governing how one appears before the tribunal, how the parties appearing before a tribunal should comport themselves? So doesn't this provision meet a majority or most of your proposed suggestions, especially the ones made by Mr. Pratt? That's my first Ms. Lickers, I carefully read your brief, and if I may, I would just like to make an observation. Of course, ideally there would be more Aboriginal judges, yet it might be even more preferable if Superior Court judges be aware of Aboriginal issues until more Aboriginal judges are appointed. And in fact, that is one of the main weaknesses of Bill C-30, and if you wish to comment on that, please do so. Now I have another question for the bar, the Canadian Bar Association. I do not agree with the bar's position, and you'll have to do a better job of selling your position to me. You recommend an internal appeal mechanism, including judicial control by the federal court. This bill, we want to avoid the possibility of the federal government using this bill to delay any claims. If there is an internal administrative procedure providing for appeals, including the involvement of the federal court, don't you think that this would mean opening the door to the federal government and giving it the possibility to delay claims? I have 3 questions. Unfortunately, I don't have time to ask more, and now I would ask you to please respond.
All right, I'll be very brief. I believe Section 12, Monsieur Le Maire, is procedural, and I think one of my colleagues mentioned that one of the unfortunate realities is that we do not know how the tribunal will seek to apply its power to make rules. And yes, it may work much better if there are good rules than bad rules. But I don't believe, in answer to your question, I do not believe that making good rules would overcome my objections to the bill.
I would just like to respond by saying that absolutely, I think for every court in this country, where its jurists could be more sensitized and aware not to be disrespectful to any member of the jurist community serving in this country, but for the position of the IBA and to be consistent in our position, where we appeared in committee in November of 2005 with the CBA at that point in time to call for the appointment of further Aboriginal justices in this country.
And then on your third question, there was great debate within our section about whether or not there should be a true right of appeal or whether the judicial review was a sufficient mechanism for decisions that seemed out of line with the jurisprudence or with the particular facts of a case. And both within the section and I've noted within the evidence before this committee, it's raised time and time again about, well, there's no appeal. Suppose you just have one judge and for whatever reason the law is simply applied incorrectly. Surely there should be recourse to that. The threshold is very high on a judicial review, on administrative review, notwithstanding the Supreme Court's recent clarification of administrative law last week, but still it's a high threshold. The CBA suggestion is simply to try to strike a balance between having a sober second thought without a true appeal function from the tribunal to the federal court. So it's not a true appeal to the federal court, it's only judicial review, but there's an internal review, and we already have mechanisms like that set up in Canada, including the Immigration Review, Refugee Board. So those sorts of internal review, second review processes already exist in other federal administrative tribunals, and we're suggesting that would meet this perceived problem with the Act as it's currently structured.
Thank you very much. Ms. Crowder, you have 5 minutes.
Great. Thanks, Mr. Chair, and thank you for coming before the committee and for your very detailed briefs. I want to specifically address Section 16.2a and Section 42 and 43 around the transitional procedures. And the reasonable minimum standards in my mind relates to Section 42 and 43. And I don't have time to go over the details of a case, but we've got a very detailed briefing from Snuneymuxw First Nation, which is from my riding. And they've laid out a number of concerns around the transitional provisions because they feel that for a band like theirs, they've been in negotiations for 10. They waited for over 10 years. They've now been in 4 years of negotiation, and unlikely it will be at a stage that would be acceptable by December the 31st, 2008, that it will be concluded. So in their view, they will be disadvantaged in that they've been going through this lengthy process. Once the bill comes into force, there are a number of questions around even reasonable minimum standards. And I just wondered why none of you addressed the transitional procedures in your briefs, or if you think they're fine as they stand.
To the extent that that the IBA referred to the fact that the Indian Claims Commission's mandate has by order in council been amended to expire December 31st, 2008, which puts an added environmental sort of pressure on the need for there to be a resolution on this bill, and whether or not it actually does, it will be proclaimed. What I missed in your question was whether or not this First Nation is at a negotiation table now.
Yeah, they are.
Are they being assisted by any third party?
I don't have that level of detail with it, but I just think that they set out a good case of if they were not able to conclude by December the 31st, they would in effect go back to being in the lineup. And they and the other 800 claims that are currently there will be at the same stages unless they've already been rejected by the minister. I know Mr. Pratt probably has some comments on that.
Yes, thank you. I think the way the transitional provisions work, as I understand it, is that is everything begins on the day the act comes into force. And so that, for example, if I'm in a number of specific claim negotiations with clients now, and if some of which have been in negotiations for 5-6 years as of now, but as you say, if we were unsuccessful and wanted to take a claim to the tribunal, we'd have to put in another 3 years, as I understand it, which is wrong, I think. So I think that's an example of that where maybe perhaps the committee could grandfather the acceptances of certain claims for the purposes of that clause, because I think where the Crown has agreed to negotiate a claim, it shouldn't matter whether that agreement took place before or after this bill came into force. And the First Nation shouldn't, I think, be compelled to put in another 3 years of unsuccessful negotiations if it already has put in its 3 years. So I haven't, you're right, I haven't addressed that situation, but I think it merits a closer look at that, and I think it's an unfair result.
The CBA, you're right, didn't take an official position on the transition provisions, but in the first few pages of our paper, we alluded to the political agreement that was reached. And like Mr. Pratt, I sit at negotiation tables, and I have specific claims on behalf of clients that are sort of in the queue that haven't been accepted yet. If the political agreement, if the financial commitment of the government and of Canada continues, the CBA does support the bill, thinks it remedies not all of the mischief, but a lot of the mischief of the current process, which is policy-driven, and provides a real impetus for the government to get cracking and get serious about reviewing claims and about negotiating claims. It's not perfect, and I've been at a table which has been negotiating also for 6 years, and it means that there's up to 3 more years to go. But the fact of the matter is that the federal negotiators are telling us they now have the resources and the commitment behind them to actually try and get these things done. So it might be wrapped up in less than 3 years.
Thank you very much, Mr. Devlin. And now the last term from the Conservative Party, Mr. Bernouche, 5 minutes.
Thank you, Mr. Chair. I appreciate all of the testimony today. Of course, you all come here with the best intentions to assist us in delivering the best product for Canada. And I know that as a parliamentarian, when I got elected, my biggest interest was systemic reform. And so, Madam Lickers, as you presented your opinion on this matter, I tend to agree wholeheartedly that when the federal government was judge, jury, and also the entity that had to pay out settlements and could choose not to, that was a situation that treated First Nations very poorly. And so this bill, I feel, is a fantastic systemic reform that is going to, in many people's opinion, bring a whole new era to the way that specific claims are dealt with. So I guess perhaps my first question to Madam Lickers would be in relation to the situation that we find ourselves in as a parliament. Of course, we can't necessarily count on our time here to be a long one in light of course, our minority circumstances, and, of course, Mr. Russell chiming in that he'd like to see the government thrown out as soon as possible. In that sense, because we have an opposition that is perhaps suggesting an election soon, and of course that would kill this bill. Do you have a recommendation to perhaps expedite our work? And not only that, I know that we have some senators in the room, perhaps that the Senate should also consider this in short order.
I think you have the opportunity, upon reflection of the witnesses that have appeared before you, to ask whether or not the amendments that are being called for can be addressed within the confines of the bill through the creation of the tribunal's rules, which have yet to be determined, by the striking of any advisory committees and councils that are required in the development of its work, the role for an oversight committee that has been agreed to in the political accord, and frankly the role of this committee and the Senate committee, who have the ability to study any subject that they so desire. Taken together as an environmental context, this is a bill that Canada really does stand at a precipice to say to the First Nations of this country, we hear you, we get it, this isn't perfect, but we're prepared to go this far.
No, I tend to agree with that. Perhaps before I move on in questions, I'd like to just clarify a few points. I think there was some opinion put forward that First Nations bringing forward claims would in fact be out of pocket should their claim not be successful. I just wanted to put on the record that's actually not the case, that any First Nation that is in the tribunal process and has their case heard won't be out of pocket for their expenses. Only the Government of Canada will. Just moving on to one part of the presentation put forward by the Canadian Bar Association, Mr. Devlin, you spoke in relation to some other perhaps claims that might be brought forward, but perhaps you thought couldn't be under the existing bill. In relation to, I believe you mentioned trap lines. Would you agree that the unilateral undertakings clause could perhaps incorporate, dependent on the opinion of the judge, some of these other claims that might exist?
Sorry, could you, which section is the unilateral undertakings, just so
I'll have to go to the bill. In section 14(1)(c). There was some opinion expressed by the negotiator for the FN that the justices would be able to have a broad mandate to incorporate such things as what you're suggesting. I'm just wondering if you might agree with that.
Yeah, well, I guess there's more specific language in section 15 sub 1G, where the First Nation may not file a claim that under G is based on treaty rights related to an activity of an ongoing and variable nature, such as harvesting rights. And then, so that's really where you get your hunting, fishing, and trapping rights. And I think that specific language may trump the the more general language of unilateral undertaking. So that's why we raised the concern there that what about historical grievances with respect to those harvesting rights? So not the ongoing exercise of the rights now, but like I said before, for example, the imposition of provincial trapline registration regulations on those treaty rights and the resulting breach of the lawful obligation by Canada to honor the treaty rights to harvest.
Thank you very much. And that concludes our questioning for today. I'd like to thank the three witnesses for being here, and I'm sure all of my colleagues would agree we wish we had more time. I'm sure there are many more questions, but we will review your briefs and take those into consideration when we consider this bill. We're going to suspend for about 2 minutes now to change the witnesses. I ask my colleagues not to stray too far. if I could ask members to take their seats, and witnesses as well. A little bit of housekeeping before we begin with our witnesses. Next week, which is the last week before our constituency week, we have committee meetings on Monday and Wednesday. We also have a subcommittee meeting scheduled for Tuesday. So if any of the committee members have any questions about process, you can have those questions ready for Tuesday. The schedule that we have essentially is that we will conclude with Grand Chief Fontaine 1 week from today. We will have a constituency week, and when we return, we will begin with clause by clause, and that constituency week will give us an opportunity to get ready for the clause by clause. In your constituency, you can get ready. I'd like to welcome our second panel here today, and for those of you who were not in the room at the beginning of our meeting an hour ago, unfortunately we have many witnesses that we want to hear from today in limited time. The bells are going to ring at 5:30 for us to go and vote, and we have, I believe, 5 different votes today, so we must end at 5:30. There's going to be 3 presentations. I will ask you I will require you to keep those to less than 10 minutes. I will give you a 1-minute warning when we're at 9 minutes, and that way you can complete your time. For those of you, if 2 of you are going to speak, I can give you a half-time 5-minute as well if you want to change at that time. Maybe I will do that. And then that will be followed by 1 round of questions of either 5 or 6 minutes. We'll see when we get to that point. First of all, today we're going to hear from Donovan and Company. Mr. Alan Donovan and I believe and Chief Fabian Alexis are here together, and together we'll be making 1 presentation of 10 minutes or less. Secondly, from Olive, Waller, Zinkan, and Waller, Tom Waller and Raymond Chaboyer will be splitting 10 minutes. And finally, from Ackroyd, we have Chief Rosalind Calahoo and Doris McDonald. So as well, you will have 10 minutes to make a presentation. So I'd like to begin with Mr. Donovan. Will you be speaking or splitting? Yeah.
We'll be splitting.
Okay, I'll give you a 5-minute warning. Anyway, welcome, and the floor is yours.
Thank you, Mr. Chairman. Just like to thank everyone for allowing the Okanagan Indian Band to come before the committee here and with our representative Alan Donovan. I won't take up too much of your time. I understand there's been many witnesses come before the committee and spoke on many changes and amendments here and there. But I'll just say that the Okanagan Band is very familiar with the specific claims process. We have settled 2 claims in the past. We have 5 waiting at the Department of Justice, and one of our claims that I'd like to share with you that we were in negotiations is called the commonage claim. Just recently, we had received a letter from the minister formally withdrawing from those claims, and we are kind of taken back because we are following the new bill, C-30, the tribunal bill, and we had some questions that we were wondering about that. And so anyways, we're here to talk about 2 amendments to the bill that we're going to propose, and the one being about the reserve creation process, and that's around specific claims. In British Columbia, there was some debate going back when reserves were created at law, and recently there was a Supreme Court decision that looked at this, and it's called the way we come. And from that case, 2 reserves that were set apart by the Indian Reserve Commission in the 1880s, but it was concluded that these reserves weren't created at law until 1938. Our claim is a little bit different. The Okanagan Reserve was set apart in the 1870s by the Joint Reserve Commission, and I must differentiate that it's not the Reserve Commission at issue in Waiwikam. and Canada purported to relinquish that communist reserve back in 1889. I must say that when Canada eliminated that reserve, they didn't tell us, and also they didn't pay any compensation when they breached their legal duty to the Okanagan Indian Band in that respect. Our legal position is that our reserve was in full existence and when it was set apart, and we also rely on the statement by the Supreme Court of Canada in Wewicum that the decision Canada owed was a fiduciary duty to Aboriginal nations during the reserve creation process, which in British Columbia stretched over a number of decades. Bill C-30 includes some language that was meant to track this law set out by the Supreme Court of Canada, and one of the parts that we are kind of uncertain with the bill is Section 14C1, and that talks a little bit about reserve, but it does not use the words reserve creation process. Also, I'd like to share with you that BC Regional Chief, AFN Regional Chief Sean Natley had written a letter to the Minister regarding reserve creation process, and the Minister had wrote a comfort letter back to Regional Chief Atleo, ensuring him that claims relating to the creation of reserve lands are admissible. We are not comforted by this letter. And as I mentioned earlier, that we did get a letter from the Minister formally withdrawing, Canada formally withdrawing from negotiations of our community-specific claim. We relied on the Minister when the Minister of Indian Affairs had accepted our claim, our commonage claim for negotiations. And the letter accepting our claim for negotiation, however, was ripped up by the future Minister. We need more than a comfort letter from the Minister, and that we're hoping will help us interpret Bill C-30 better. If Canada's intention is to address these breaches to obligation during the reserve creation process, then Canada should say so in the legislation, and that's what we're proposing. And we have done that in a clear way in our submission on page 4 of our written submission we've provided. Next area I'd like to speak is regarding claims over $150 million. Right now, with the claims definition, we need to get away from past differences as to the validity of a specific claim. When Canada brought forward this legislation, its goal was to change Canada's existing role as judge, jury, and the word I didn't hear from one of the MPs earlier was the word executioner for specific claims.
5 minutes.
That goal is achieved in part by the creation of this tribunal, but what we're proposing also is that where we're at right now, we won't have our access to the tribunal will be changed, will dramatically impair us, because if we were to go before them, we would have to lessen our claim 80% down to $150 million, because we've had our claim valued at $750 million by an appraiser. So we're hoping that we can change some of the laws around the $150 million, and then go from there. I'll just turn over the next few minutes to Mr. Donovan.
Thank you very much, Chief Alexis. Thank you, committee. Having tagged off, I will just turn quickly to the two issues that Chief Alexis has brought forward and comment on them briefly. The first is the wording of Section 14, sub 1, sub C. Now, the Minister says in his comfort letter that section is meant to deal with claims relating to the reserve creation process, like the Supreme Court of Canada said in Wewicum. The committee members at various times have said that's how we understand it as well. Your expert witness, Brian Schwartz, has said that was the intention of the drafters. So all we're saying there is, why not make it clear? Why not use that language? And so there's no possible doubt after the fact. Now, I know many of you might think, well, how could a lawyer possibly argue that that wasn't what was intended? Well, believe me, lawyers are willing to try any kind of argument on for size, and I wouldn't be surprised at all if a Department of Justice lawyer 3 years from now, 5 years from now says, well, so what if the Committee on Aboriginal Peoples thought that's what it meant? It doesn't use those words, so they must have meant something different. We're saying track what everyone knows this section is meant to say. We've provided draft wording, and that can be examined. But let's do what we're intending to do, and this should be an easy amendment. It shouldn't be something that takes any time at all. We're just doing what the minister says and what everyone says this section is meant to say. It'll bring a lot more comfort than a comfort letter, that's for sure. On the $150 million cap, I had the privilege to read through the transcripts of your hearings to date, and must compliment you on your careful analysis of this legislation. The honourable member from Winnipeg South has asked almost every witness this rhetorical question: is wouldn't it free up a lot of time and resources for the government to deal with the big claims now that we're going to be able to deal with the little claims? And there's a lot of sense to that. The trouble is that's not what is happening on the ground. Canada right now is dealing with the little claims. In BC last year, they dealt with about 15 or 16 little claims, less than 100,000, some of them. That's good. Those are important claims in their own right. But has that freed up the time and resources of the government to deal with the big claims? Not in Okanagan's case. In Okanagan's case, they've submitted a 70-page legal opinion, and the government's response has been, well, we'll pull out of negotiations after agreeing to negotiate. The Okanagan sends in a supplementary legal opinion, and the government provides a second opinion. No, we won't negotiate.
1 minute.
And there's no appeal. There's no appeal process. They can't go to the Indian Claims Commission because that route's been shut down. They can't go to the tribunal because of the cap. And we hear, well, there's going to be a new process, the cabinet process. But can we get into that? Well, no, the choice is the minister, and the minister is the one who's closed the door. And so it's like Alice in Wonderland. There's jam yesterday and jam tomorrow, but never jam today. And that puts Minister Strahl into the role of the Queen of Hearts, and I'm sure he doesn't want to sit in that role. If we can establish either eliminate the cap and have claims paid out according to what they're worth, or have the tribunal simply look at the claim and tell the government it's valid. You should go to the negotiation table. It's the second best solution, but it's a whole lot better than closing every door that's available to a First Nation to have its claims heard on legal principles.
Thank you very much, Mr. Donovan. Thank you again for your timeliness. Next, we'll go to Mr. Waller and Mr. Chaboyer. I'll tell you when it's 5 minutes and 1 minute.
I think, Mr. Chairman, I'll be doing the speaking on behalf of my client. I appear here today as legal counsel on behalf of the Cumberland House Cree Nation. I've been asked to speak, although Councillor Raymond Chaboyer, a member of the Cumberland House Cree Nation Council, is present. Chief Walter Seawap had planned to appear, but a death in the community has prevented him from attending in person. In terms of my background, I have more than 35 years in the practice of law representing First Nations on claims work. My experience predates the existing specific claims policy. I was legal counsel for the Assiniboine people in the negotiation of what is known as the White Bear Pheasant Rump Ocean Man claim, possibly the first specific claim settlement in Western Canada. I've represented several First Nations in Saskatchewan on treaty land entitlement claims and served as a consultant legal counsel to the FSIN when the framework agreement was negotiated. I've appeared in a number of Indian Claims Commission inquiries on behalf of First Nations. 3 of those have involved full inquiries with the release of extensive reports: the Cumberland House Cree Nation claim, which is what we'll discuss today, the claim of the Carry the Kettle First Nation to a reserve in the Cypress Hills, and a claim by the Papikasis First Nation arising out of what is known as the File Hills Colony Experiment. We understand the practice of the Commission is to have a presentation of approximately 5 minutes, and we'll try and stay fairly close to that. Cumberland House has filed a brief, and we do not intend to read the brief. Generally, Cumberland House is supportive of the proposed bill We believe it deals with several key issues that need to be addressed. However, the legislation is only a start, and in our view, the committee needs to understand this. In the brief, we've identified 3 areas where we would suggest that the committee should focus its attention. The first of those is the issue of delay. Under INAC's existing policy, a First Nation is required to file its specific claim. The documentation submitted is then taken by INAC and Justice for review and opinion, and it literally disappears for years. In my experience, that's often more than a decade. At some point, Canada appears with an answer. If the answer is positive, in the sense that Canada is willing to negotiate a claim, often the basis of the settlement is much narrower than the claim was originally submitted. And by way of example, oftentimes when a First Nation submits a claim based on an improper surrender, Canada will purport to validate the claim, but it will do so on the basis of an improper sale or improper compensation. And that's essentially what happened with the Cumberland House claim. If a claim is rejected, First Nations have had the option of requesting the Indian Claims Commission to conduct an inquiry. That process takes some time. It has had the advantage, however, of being the only forum in which Canada was required to share its work product and defend its position. However, the ICC process itself involves a considerable period of time. And then if the Indian Claims Commission report is positive, First Nations are left for a number of years while Canada considers its response. In the 3 claims that I mentioned before, the Cumberland House claim, this complaint or claim was originally submitted to Canada in March of 1986. There was a revised complaint submitted in September of 1988. Canada's preliminary response was in December of 1997. It was referred to the Indian Claims Commission in February of 2000. The ICC report was released in May of 2005, and Canada's response after a mere 34-month period has not yet been provided. And we met with Indian Affairs earlier today, and they estimate that it will be several months more before we will hear. On the Papikassis First Nation claim, its claim was submitted in 1986. The request for the ICC inquiry was made in April of 2001. The ICC report was dated or released in May of 2004. After 24 months, Canada rejected that recommendation. On the Carry the Kettle claim, it was submitted in 1992. That was referred to the Indian Claims Commission for an inquiry in 1996. The Indian Claims Commission reported in July of 2000, essentially telling Canada that it did not have to negotiate, and that report was accepted by Canada in something approximating 5 months. An individual from Cumberland House who was born in the year in which the claim was submitted to Canada for review under its policy is now 22 years of age, and we still haven't received an answer. There's a well-recognized legal principle that says justice delayed is justice denied, and I think that in the specific claims area, this is something that has come to pass. But that issue is, in our view, addressed in the bill. The second area mentioned in our brief is the need for an independent review process. You've heard a number of witnesses provide comment on that. At the present time, Canada controls all aspects of the claim system, and this is problematic. Whatever the reality, the perception is the system is not fair, and from our perspective, the bill is an improvement. The third area identified in our submission deals with the issue of the need to have the process recognize the unique nature of the relationship between Canada and First Nations. While under the bill, a committee comprised of members of the tribunal will determine rules on process and procedures, we believe it is important in setting those rules that Canada and members of the tribunal do not lose sight of the unique nature of the claims and the relationship that exists between Canada and its First Nation people. If all the tribunal is intended to do is duplicate the role of courts, you could accomplish this by simply amending Canada's Crown Liability and Proceedings Act by adding a provision similar to Section 19 from the bill. The final points that we want to emphasize here today is that while Bill C-30 represents a start, there are some claims excluded from the process, and is noted in the brief, some key issues in the resolution of claims have been excluded from the jurisdiction of the tribunal. We've identified in the brief the need to have some effective mechanism that will allow First Nations to ensure that land can be added to reserves as part of settlements, and this is particularly important to the Cumberland House Cree Nation since its existing reserve land in a modern context is of poor quality and cannot support economic development for the First Nation. The fact that the proposed process will not apply to claims above $150 million also has particular impact on Cumberland House. Following the clear recommendations of the Indian Claims Commission and applying the quantum of dollars that have been offered by Canada on other claims within Saskatchewan, the Cumberland House claim arising out of the Cumberland 100A reserve could exceed $250 million or more. As is outlined in the brief, Cumberland House is most concerned that its claim and other large claims will be lost as Canada focuses on the process that is outlined in the bill. While process is important, in the end it is the outcome that is most important for Cumberland House and for all nations. You have a bill before you. We think that the passage of the bill is preferable to holding it up. The situation that currently exists is that there is no recourse to the Indian Claims Commission. You've essentially started down a path, and we think you must finish it. The bill isn't perfect, but it's an improvement over things as they exist today.
1 minute.
Thank you. That's it.
And next we will hear from Chief Rosalind Callahoo and Doris McDonald. You'll both be speaking, so I will give you a 5-minute point, okay?
Thank you, Mr. Chair. Good afternoon. I am the great-great-granddaughter of Michelle Callahoo, who signed treaty in 1878 via adhesion to Treaty 6. I'm here today on behalf of over 700 reinstated members of the Michelle First Nation who were reinstated under Bill C-31. What I would like to present to the committee today is the issue of discrimination throughout the Michelle history. The whole band enfranchised in 1958 under a section of the Indian Act 112 that was later repealed because it was deemed to be discriminatory. Bill C-31 was also discriminatory. I stated that there's 700 plus members reinstated. However, there's probably approximately the same number that were not reinstated because they were enfranchised under the banned enfranchisement. Bill C-31 did not address that. They only addressed individual enfranchisement. My third comment regarding discrimination is the specific claims policy and access to it. In 1998, we had concluded an inquiry from the Indian Claims Commission. That inquiry made a recommendation to Canada that Canada should grant the Michelle First Nation special standing to file a specific claim. In 2002, after 4 years, the Minister of the Day of Indian Affairs refused to give us that special standing, and it was not adopted. The recommendation was not adopted. Our sole recommendation here today to this committee is to propose an amendment to the definition of First Nation in Bill C-30. In order to bring a claim before the specific claims tribunal, a First Nation must meet the First Nation's definition under Section 2 of the Indian Act. This defines First Nations to mean a band as defined under the Act. This definition needs to be expanded to include the Michelle First Nation, who would be First Nations, but not for Canada's breach of lawful obligation, because Canada's breach goes directly to the status of the Michelle First Nation. The Indian Claims Commission did note that Canada should not benefit because of a technicality. In our case, Canada is still benefiting from its own wrongful act. That is, it points to its own discriminatory as the justification for not granting us standing under the policy. Parliament would continue this wrong by enacting Bill C-30 without the requested amendment. One of the purposes of Bill C-30 and the reason why it was endorsed by the Assembly of First Nations is that it removes the non-binding status of recommendations under the former Indian Claims Commission. Bill C-30 is a positive step, and we endorse it. However, the benefits of Bill C-30, as it is currently drafted, exclude us because of the catch-22 position that we are in. We are not recognized as a band, but we say we should be a band. We can't argue that we should be a band. The basic principles and values of Canadian society are reflected in the constitutional provisions designed to protect the rights of Aboriginal peoples, to abolish discrimination. These basic principles and values need to be applied to our situation. We have the same issues before us as all the other First Nations in Canada. However, we have no platform to bring them forward. We respectfully urge the committee to recommend that Bill C-30 be amended so that we may have equal access to the legal processes within Bill C-30, which Bill C-30 set out. Thank you to the committee for allowing us to attend today.
Thank you, Chief Kalahu. And now Ms. McDonald.
Yeah, thank you. I'm Doris McDonald. I'm the Vice President of the Asiniwaju Nation. Asiniwaju and Cree means the Rocky Mountain people. Our community emerged as a distinct society in the first 2 decades of the 1700s when Iroquois men from the Six Nations migrated to the Rocky Mountains. They intermarried with other indigenous peoples of Beaver, Sicanni, Cree, and other nations and settled in the Athabasca River Valley in what is now known as Jasper National Park. Our ancestors were expelled from Jasper National Park when it was created. At the time, we were advised by the federal government that we could move wherever we wanted and not be bothered again. Our ancestors chose to relocate to the remote area of Grand Cache, and here we lived undisturbed for almost 60 years until coal was discovered and a mine developed in Grand Cache. The town of Grand Cache was built on our settlement, and our hayfields and pasture lands were bulldozed to build the town. At the time that the Dominion government made its first preparations for Treaty 8 in the early 1800s, it identified our people at Jasper House as one of the groups it would enter treaty with. However, when the treaty commissioners traversed northern Alberta in 1899 and took allegiance to Treaty 8, they did not travel to Jasper House. We have never adhered to a treaty or have been offered the opportunity to do so. Some of our ancestors entered into Treaty 6. Chief Michel, one of the descendants of the original Iroquois settlers in Jasper House, and his family migrated to Lac St. Anne outside of Edmonton. He and his extended family and followers signed an adhesion to Treaty 6 in 1878. The historical records show that some of our ancestors applied for Métis scrip, which were denied on the basis that they were Indians. The government of Alberta has recognized that we have an Aboriginal right to hunt, fish, and trap. In the early 1900s, Alberta researched our history and concluded that we were Indians within the meaning of the Indian Act because we are entitled to be registered as Indians. Unfortunately, Canada has not shared this opinion and has refused to register our members as Indians. We currently have approximately 400 members living on the 4 cooperatives and 2 enterprises near the town of Grand Cache, and these cooperatives and enterprises were created to hold land communally, land which was set aside by Alberta for us in the early 1970s. What we are seeking is recognition by Canada that we are a First Nation and an Indian band within the meaning of the Indian Act. We are seeking an adhesion to Treaty 8. Today, we're striving to maintain a standard of living for our people comparable to that of other Albertans. It has been a struggle for our people to adjust to the loss of their traditional livelihoods and way of life and to adjust to the values of mainstream society. We welcome this opportunity to present our concerns about Bill C-30. Our concern is that it's limited to the definition of First Nation in Clause 2 of the bill. This definition is limited to bands as defined by the Indian Act or nations which have entered into comprehensive land claim agreements or self-government agreements. We request that the definition be expanded to include First Nations who qualify to be bands under the Indian Act, but for Canada's breach of its lawful obligation. Bill C-30 excludes from the jurisdiction of the specific claims tribunal whose First Nations, like the AWN, whose claim is based on a breach of a lawful obligation which directly relates to their status under the Indian Act. Currently, there is no policy or tribunal available to the Asiniwajuniwak to pursue its claim outside of the courts. We are seeking an adhesion to Treaty 8 and recognition of our status as Indians as under the Indian Act. We believe that Canada has breached its obligation to us in two ways. First, by failing to treat with us, and secondly, by failing to register our members as Indians. Under Clause 14(1)(c) of Bill C-30, a First Nation can bring a claim for failure to provide reserve lands, including unilateral undertakings that give rise to fiduciary responsibilities at law. We believe this applies to us. And we understand that the Supreme Court of Canada has held several times that the honour of the Crown is at stake and it must deal honourably with the legitimate claims of First Nations. We ask for this committee's support to help achieve justice and dignity for our people, and we thank the committee for its consideration.
Thank you very much. We'll have time for one round of questions. We can do a 6-minute round. If the bells start or the white lights start flashing, we'll complete that fourth questioner. But I'd like to begin with the Liberal Party. Ms. Neville, you have 6 minutes.
Thank you very much. I'm just going to take a very few minutes, and my colleague, Ms. Keeper, will follow up. My question is directed to Chief Alexis and Mr. Donovan. Your issue and your arrival here today have been heralded by many. We've heard about the issues that the Okanagan community is facing. You made the proposal of a claim over $150 million being heard by a tribunal with reference to Cabinet. Do you have any other suggestions as to how these claims over 150 might be dealt with?
Well, it's a suggestion, right? And it may not be the best suggestion, but we're hoping that we could have the tribunal look at claims that are actually, the validity of it all. Right now, we're kind of in limbo because we don't quite fall within the definition of the specific claim because, as I said earlier, our land's been appraised at over $750 million. We could fall within the tribunal if we agree to knock our claim down to the $150 million cap. But we're not willing to do so just yet. We'd negotiate that. Anyways, I'll just point it over to Mr. Donovan to add to any of his suggestions on that point.
Yeah. Essentially, up until very recently, we could have done exactly what Chief Alexis suggested by going to the Indian Claims Commission and getting a non-binding ruling. That avenue had its drawbacks, but it's better than nothing. And right now, Canada's eliminated that access to the Indian Claims Commission, and then following up quickly after that, withdrew from negotiations of this $750 million claim. And so if the cleanest way is just letting the tribunal rule according to law and having the First Nations obligations be determined by the same legal principles that would apply to any other Canadian, not singling them out for a second-class treatment. If that's not on the table, then at least having the tribunal say to the Government of Canada, you know, they're right, this is a valid claim, go and negotiate it. We're not going to value it, but we're telling you there's a lawful obligation that's been breached when you took away a 28,000-acre reserve for nothing. That would, we would hope that with that in hand, Minister Strahl would be able to turn to his Department of Justice colleague and say, look, there is a legal obligation. We're going to negotiate here.
Thank you.
Thank you to our presenters. I have a couple questions, and one of them is my concern as well is similar to what has been raised, that there is, as you said, this has been represented as a process that would be in place to respond to the fact that there was only non-binding recommendations through the previous commission. And yet, as you said, there's sort of this kind of Alice in Wonderland type of atmosphere or sense, I guess, maybe about it, and that's where, you know, we all want assurances, because my fear as well, and Mr. Waller might want to respond to this as well, is this issue of the process where you know, only certain claims move through, and so if, I mean, and aside from the large claims, is where as Mr. Waller has in his presentation, the limitation represents a challenge for many claim settlements, since First Nations may not be as interested in the dollar amount of the compensation as in the ability to acquire reserve land. So if it goes into negotiations even, the process is that if it's deemed rejected or is rejected, the only avenue then is the tribunal process, which only can make a monetary compensation. So I'd like to just I guess, talk about whether you feel that the protocol or the political agreement has within it any assurances to deal with these issues, these concerns.
You have about a minute and a half.
Okay. The protocol, the political agreement, does have assurances. The question is whether those assurances will be complied with. And in a sense, it seems like a gentleman's agreement, which has been described as something that's not an agreement and is not made between gentlemen. And the plain fact is that political agreements in the past have been broken. The residential schools political agreement said that anyone who attended residential school would be eligible for the 10 and 3 compensation. Mm-hmm. That was changed, and the legislation said that anyone who resided at residential school would be eligible. So what Chief Fontaine signed his name to was not followed through. It's in the political agreement, and it's still there. And there's a promise of a process for claims over 150 in this political agreement. But what the minister has suggested is that the minister himself will be the guardian of the gate. If we could have a process that would comply with legal principles and would allow us to make our case, that's all the Okanagan have been asking for.
Thank you. Monsieur, oh, sorry.
I think I would answer in this way. First of all, our Cumberland House is one of those First Nations that are included within the Federation of Saskatchewan Indian Nations, and they therefore support the legislation. We recognize that it isn't perfect. The political agreement is another agreement which, in my view, puts the honor of the Crown at stake. The Crown has committed to a process that will solve both of the issues that you've identified, the large claims and the addition to reserve of land. One could sit here and note that in most First Nation claims, what you're arguing about is a breach by the Crown of the honor of the Crown already. But at this point in time, certainly my client is prepared to take that chance once again.
Thank you, Mr. Waller. Monsieur Levesque.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. I will share my time with my colleague. I will try to be as brief as possible to give my colleague time to ask his question. Now, several concerns have been raised with regard to the bill, including whether the province has the right to decide whether it wants to be present at a hearing before the tribunal or not, the compensation cap, the threshold, and also other shortfalls in the bill have been raised. And I'm asking each of you this following question. If you had one recommendation to make to improve the bill, what would it be?
Who would like to go first?
Go ahead.
Go ahead.
Well, if I had one, I would say the $150 million cap, addressing that through removing it or through establishing a process, and Chief Alexis would say fix up Section 14.
Mr. Waller?
I think from our perspective, we'd say simply remove the cap.
Thank you. Anyone else want to? Chief Calahoo?
Yes, my recommendation would be, as I spoke to amend the definition to include a clause that would allow First Nation groups to file a specific claim.
Okay. Ms. McDonald, did you want to?
I would agree with Rosalind Calahoo it's to the definition of First Nation in Clause 2 of the bill, because it's limited to bands and as defined by the Indian Act, and that excludes our community. So mine's the same as Chief Calahoo's.
Thank you. Monsieur Lemay, you have about 3.5 minutes.
Oui, je vais essayer d'aller vite.
I'll also try to be brief. Mr. Donovan, a little earlier you commented on Section 15(1)G. Well, to me the issue is clear. I don't know how you feel about this, but a First Nation may not file with the tribunal a claim that, and then 15G, it is based on treaty rights related to activities of an ongoing and variable nature, such as harvesting rights. That's not quite clear for you?
It's clear to me what the Section 15G is getting at. They're saying that there are certain treaty rights that the government would see as specific claims if they breach them, and others, if they breach them, they would say those aren't specific claims. In our submission for the Snuneymuxw First Nation, we said that that distinction wasn't, in our view, a proper one, because if you breach a treaty right, you breach a treaty right, and you should act accordingly and compensate.
Okay. J'ai une question générale et je vais terminer là.
I have a general question, and I'll conclude with this. Do all the witnesses feel that the tribunal should render decisions which are final and without appeal?
Start with Mr. Donovan, maybe?
We focused on the two issues that we focused on because those are the most important ones to Okanagan. The question you posed, sir, is highly important, and it could go both ways. The difficulty with having an appeal to the courts is that Canada could then run a financially exhausted First Nation through the court system, and unless there's funding, and Canada generally does not fund First Nations in the courts, unless there's funding, they'd be able to beat them by attrition rather than on the merits. You'd like to think that there would be some mechanism to make a correction. On the other hand, if there was something evidently wrong, and the earlier witness suggested a layer of internal review.
Chief Alexis, did you have anything to add to that? No?
I just I concur with Mr. Donovan on his point. I'm not quite familiar with all of the bill. My focus was on those 2 points
Right.
as we've raised. So I won't comment anymore on that.
Mr. Waller?
I think I would answer the question in this way, sir. Bill C-30 is the product of a set of negotiations and represents a compromise in our perfect world, the tribunal wouldn't have the final say. But we live in an imperfect world, and as I've indicated before, the First Nations in Saskatchewan have adopted a resolution to support the bill. We think what's in the bill is better than not having the bill go forward.
Chief Callahoo?
Yes, I would just like to speak maybe to the courts. We're currently before the courts, and what we're finding is because we've been denied access to the specific claims policy, we're faced with statute of limitations in the courts of Canada. And as well, our treaty rights are being confused with the Indian Act. We have never relinquished our treaty rights. Our treaty rights are forever. So yes, for our situation, it's important to have that appeal.
Right.
Thank you.
Ms. McDonald, did you have anything to add?
No, because right now, as it's being proposed, it doesn't include our community, so it just goes back to, you know, the inclusion, and that's about it.
Okay, thank you. Thank you. Ms. Crowder, you have 6 minutes.
Great, thanks, Mr. Chair, and I want to thank the witnesses for coming before us today. And I think Chief Callahoo and Ms. McDonald, you've made very clear the recommendations around what needs to change in terms of the language, so I appreciate your clarity around that. I want to address the $150 million cap. Today, when the Canadian Bar Association came before us, they specifically recommended that there not be a blanket cap in the amount that the tribunal may award in compensation, but rather the Bill C-30 contain a provisional cap of $150 million, subject to the tribunal's ability to assess the complexity of a claim. Do you think that would address some of what you're raising?
Go ahead. It could, Ms. Crowder, but the difficulty I have with the suggestion, and I haven't read their brief, so I don't know exactly what they're saying, is how do you tell whether a specific claim is simple or complex? These are judges who are going to be determining the answer, and I would think that they'd be fully qualified to deal with any specific claim on the merits, whether it's simple or not. You know, in the one that Chief Alexis has brought forward, it's the taking of a 28,000-acre reserve for nothing. Sounds simple to me, but there are some fairly complicated legal issues perhaps about how you quantify damages. I would certainly think there's, other than the size of that claim, there's nothing out of the ordinary, and the tribunal ought to be able to rule. But I would say the tribunal should be able to rule on any specific claim, because I don't know how you could possibly draw a line between easy and hard specific claims.
So in your view, it should be that the cap should just be dropped?
Either the cap dropped or some mechanism at very least that the committee, the tribunal could direct Canada to negotiate, even if the amount is over the cap.
Mr. Waller?
Well, I think if that's a change that the committee decides to recommend, that I would agree with Mr. Donovan's comments.
I want to touch, because our time is so limited, I want to touch, I touched on it earlier around Nunamut's, they put together a comprehensive brief, but I want to talk specifically about the transitional procedures in Section 42 and 43, and I wasn't clear enough around my question around Section 16 around the requirements in filing. And I wonder if you've got any comments around the fact that people could be in the claims process, the specific claims process, could have been accepted for negotiation, and with this new bill, as the requirements are laid out, could in effect not meet the new requirements, potentially. I wonder if you could comment on that and on the transitional, how the transitional procedures could potentially disadvantage people who've been in the loop for years and years.
To take Okanagan as an example, that claim's been filed 2 decades ago. It was accepted for negotiation 5 years ago. It was rejected, or Canada withdrew 2 months ago. So where we would be in the transition provisions is under Section 43. And despite actually Okanagan would have to refile its claim and wait for 3 years, and then it would be in the same lineup as anyone else, despite the fact that they've been waiting a generation. Now, our firm has filed over 100 specific claims. Some of our clients will be lucky enough to have their claim rejected the day after the bill is. Bingo, that's great. They filed 5 years ago and their claim's rejected. They can go immediately to the tribunal. But while that would be good news for them, it's pretty arbitrary. And trying to address claims that have been in the system for a long time, that the First Nations put a lot of time and effort into resolving, seems pretty reasonable that you give them some degree of priority access. And the other problem with the transition provisions, as they're worded, is that they deem claims in negotiation to be in negotiation starting the day after the bill. So you could have a claim that's been there for 5 years, for 2 years, doesn't matter. The day after, that's day one. Now, that has a fairness problem with it. I think that's fairly self-evident. But it also has a practicality problem because it means that all of the claims that are in negotiation now, and there are a lot, they're all going to come up for tribunal eligibility on the same day. On the same day. And that doesn't need to be the case. You cross out that one line from Section 42, the deeming provision. So this is a good news, bad news. The good news is if you've been in negotiations for 3 years, you can go to the tribunal. The bad news is you're deemed to start negotiations when we say so. It doesn't make any sense, and it creates this automatic, it's like an instant backlog. Add water, and you've got a backlog. There's no point in doing that, even if you didn't care about the fairness, and I'm sure everyone does. So those transition provisions can be cleaned up by a few really simple amendments that this committee could and should, we'd say, put forward.
Anybody else? There's a few seconds left. Anyone else have a comment they want to make before we conclude this?
No, I think not on that point.
Okay. Thank you. And our last questioner today, as I said, if the bells start ringing, just ignore them, will be Mr. Bernouche, 6 minutes.
Thank you, Mr. Chair. I'm going to split my time with the member from the Znethy Municipality, Churchill River. I like hearing that riding name because remember the last time I would refer to it, there was a member on the other side with that riding. But my question is perhaps going to go to Mr. Donovan. I appreciate you following the testimony that I've given, or sorry, the questions I've asked in previous meetings. And my question would be in relation to the cap, as you've suggested that we remove it. Many have lauded the fact that our government has attached $2.5 billion to the tribunal over 10 years, and which would be delegated at about $250 million per year. So by removing the cap, how do you think that might impact the tribunal's ability to be able to, I guess, deal with the highest number of claims possible in light of the monetary limit that's been placed upon the tribunal?
If you simply removed one cap, the $150 million cap, and you didn't remove the $250 million cap, you'd have a potential problem of delay of settlement of the claims because one significant claim could deal with a lot of that, a lot of the money. If you opted for our second suggestion, then that problem wouldn't emerge at all, because the government has said that money for the larger claims will come out of a different pocket or a different silo, and so that wouldn't generate any additional backlog or interfere with the ability to process claims along the lines intended.
You would agree, though, that $2.5 billion is a sizable amount of money to set aside from a government budget, at least for this purpose?
From, as one Winnipegger to another ex-Winnipegger for me, that sounds like a lot of money. On the other hand, if I were to, say, take your house and say, Mr. Bernouche, I won't give it back, but I'll let it be decided by someone that you can have input into appointing how much I owe you, but I'm only going to pay you a quarter. of how much it's worth. Because, you know, the value of your house, paying the full amount, I have some fiscal problems with that, sir. So that's what, $2.5 million is a lot of money, but the appropriate amount of money in our submission is the amount of money that by legal principles is owing to First Nations. And that issue of justice, as the minister calls it in the political agreement, the legal and moral imperative, that's to pay First Nations what's legally owed to them, and not to say, gosh, we'd like to, but we can't afford justice. That's our submission on it.
But with the cap in place and going towards specific claims beneath the $150 million, I am suggesting to this committee that the process will be able to bring forward resolution for a number of claims. As we know, there's a much smaller number of claims that are above 150, and so the bulk of the backload is, of course, below the 150 mark, at least based on the information we have. But I'm going to leave it there and hand off to our new colleague.
You have about
2 minutes, Mr. Clark.
Okay, I'll try to keep this really short. Mr. Chataway, you're from my home riding, and I recognize Cumberland House, Cree Nation. My riding is very dear to me. I haven't heard you talk here yet today, and I'd just like to get your opinion, or what would you suggest for recommendations for the Cumberland House Cree?
Thank you for addressing me like that, Rob. And I'd just like to congratulate you, first of all, for your win there on Churchill riding. And I kind of restrained myself from talking too much because I did bring our legal counsel along with us, and he's quite well versed in all of this. But since you want my opinion, yes, I do agree quite a bit with what's being said here around the table regarding the cap, and that's going to be a problem with our First Nation. And you know, we've waited over 22 years since, and we still haven't got any answers or resolutions to our claim there. And this is something that's, like I said, that's been going on for 22 years. And economic development, the way it is back home on the east side of Saskatchewan, you know, this is something that has been a long time coming, and we put a lot of weight on this thing, that this thing will carry us over on the when it comes to economic development. And this cap here poses a big problem to myself and my community and our legal counsel here. So with the suggestion that it be removed, I totally agree with that. But like our legal counsel Tom Waller had suggested, that we support Bill C-30, but with some recommendations, and that is one of them that we would strongly suggest. Thank you.
Thank you very much. That concludes our questioning today. I'd like to thank all of the witnesses for being here today. I know that many of you traveled a long way, and we certainly appreciate you sharing your thoughts with us today. I also want to thank my colleagues for helping me to keep the trains on time. We stand adjourned until Monday at 3:30.